So I want to make sure that you heard what I just said to you. Did you hear what I said?
Yes, ma'am.
Have you consulted with your attorneys about this?
Yes, ma'am.
Right. If you have any disagreement with the way it's being conducted, now is the time to speak. All right. All right.
The evidence showed that this defendant was driven by selfishness and committed an unspeakable act against his own flesh and blood in this case. I believe that the evidence in this case and the jury's finding that this man intentionally killed his child in the worst way possible necessitates this sentence and only this sentence.
The state's recommendation is the very least that anyone could deem just under the circumstances of this case, and I will follow the recommendation. Sentence of the court is life to serve in confinement without parole.
Do you regret now or have any second thoughts about not seeking the death penalty in this case?
You know, I don't, Ross. In looking at a death penalty case, there's basically two factors that I look at. One is from a legal perspective, and by that I mean, are there aggravating factors in a case? Although it's not written, my general policy is I minimally want 2 or more aggravating factors in a case. This certainly had one, just the nature of the facts and what happened to young Cooper would have qualified in that regard. But as you heard Her Honor state a moment ago, this defendant had no prior history. There were no additional victims or anything of that nature, and so we didn't really find another aggravating factor. Second, in all candor, this was an unusual case. This was a case where the factual pattern had not been sought, at least from what we could find in Georgia, on a malice murder conviction before. Although we felt very strongly about it, you still don't know what a jury will do. And so I don't regret it, and I don't look back in hindsight at 2020 at those type of decisions. I think it was appropriate at the time, and I think this sentence is appropriate today.
What feeling or comments did you get from the jurors about how they handled that evidence and absorbed it?
I think they absorbed it in a very systematic way. I think the first day, talking to the foreperson and a couple other people, the first day they were kind of, working their way through how do they go through this process. And then they created a plan where they were going to go through and discuss each issue. And when they did it, each juror was going to be allowed to have their say, so no one would feel like they were left out of being able to deliberate. But when speaking with them, they didn't seem to have, they were very thorough in their examination of the evidence, but they really didn't have a lot of questions about the evidence once they had gone through it.
They fairly deliberated and discharged their duties and found the defendant guilty of what factually was a horrific experience for this 22-month-old child who had been placed in the trust of his father, and in violation and dereliction of duty to that child, if not love of that child, callously walked away and left that child in a hot car in June in Georgia in the summer to swelter and die.
This case, we believe, and a jury, I think, spoke very strongly and convincingly that they believed it as well, that this was not an accident, this was an absolute intentional act.
My final observation is this, Mr. Harris. I went back and reviewed and thought about your statement to the police and your statement to your wife when you were taken into custody. And it stood out to me that in both of those, you took the occasion to express your wish that you would be an advocate so that people would never do this again to their children. And I would say, perhaps not in the way that you intended, but you in fact have accomplished that goal.